This is News 12 Law Call.
Hi there, good Sunday and welcome to Law Call. I'm Neil Gordon. Tonight, the answers to your legal questions. Here's what's on the docket for this evening. We're going to talk about running your own small business. You may have a super idea, but what you need to know about forming a company, trademarking your name, and some pesky details like HR issues. You want to call us with some questions. The number is 844-706-1212. And when do words cross the line? We'll explain the concept of defamation later on in the program. First, we welcome back in the founder of the Hawk Law Group, Vic Hawk, to kick things off. How are you, sir?
Doing great. Always, Neil.
Outstanding. Yeah, me as
this
well.
This is fun.
Yeah, it is fun.
Yeah.
You're exactly right. And this is up my alley, being a small business owner as you are, so we're excited. But before we bring on attorney Ed Enoch, we have an email question from Sean. And Sean mentions, Vic, that a big box fell off the top shelf on him just a couple days ago. He sprained his neck, and the store's insurance has already called him twice. So if they ask Sean for a recorded statement about what happened, should he give one?
Sean, no, you shouldn't give one. What I like to do is call the insurance company up and say, look, if Sean gives a recorded statement, can we get a recorded statement of your employees that were involved with that box? And you know what their answer will be? No. They won't do anything that might put you on a fair plane with them. The purpose of the recorded statement is to lock down your version of what occurred in their best light, and to box in your injuries in their best light. And that's why they want that recorded statement. It's to their advantage. The reason that they won't allow you to get a recorded statement of their employees is they understand that there's an advantage to be gained by the recorded statement. And so you just have to stand your ground, get to a good trial attorney to help you out. If the injury is small, the medical bills are small, you can file on their MedPay provisions to get your medical bills paid. If it turns out to be a significant injury, then a good trial lawyer will be able to get you fair compensation for what you have to go through.
Okay, and Vic, if someone else watching us has a question about a slip and fall like that, or DUI or personal injury or something off topic, you can still get some help. Just go to hawklawgroup.com to get started on a live chat. But our topic tonight, small business and the law.
Absolutely. And tonight I brought on a good friend and a seasoned lawyer, one that really understands business and dealing with problems related to businesses, and that's Ed Enoch. Ed is here with a trove of experience, and we're going to start off tonight talking about trademarks. Now, Ed, can you explain to our viewers what is a trademark? How do you get a trademark, and what does that mean for you? What benefit is it?
Sure. All right, Vic. We'll start with what is a trademark. Trademark is a name that you use in business for a product or a service. So it's the name of your company. It can be the name of your company, or it could be the name of an actual product. You actually get trademark protection just by using it, but you register to get more protection. So you can either register at a state level, Georgia or South Carolina has a state filing, or ideally you register at the federal level, which is the highest level of trademark protection that you can get. That covers you nationwide. And we're having a lot of those issues now because of the internet.
Makes a lot of sense, Ed, and we'll get back to that point in just a moment. We do have our first call. Allie from the Augusta area. Hi, Allie, can you hear us?
Yes.
Super. How can we help you?
Yes, my question is this. What are the legal ramifications, if any, that a business owner faces if he or she were to close up shop without letting the employees know? Because I realize Georgia is an at-will hire and an at-will fire state and doesn't fall under the at-will fire from the employer.
Okay.
Ed?
I didn't hear any of that.
Okay, well,
Paraphrase
yeah,
that.
Yeah, what Allie is asking is, what is the business owner's responsibility when they're going to close the business? Do they have to give the employees notice that they're going to close the business, or can they just close the business all of a sudden and say, hey, you no longer have a job?
So in Georgia and South Carolina, there's no requirement that the business owner give any kind of notice to the employees. Unless it's a really large business and it's a large downsizing. Over 100 employees, there's a federal law, a Warren Act, that requires that you give notice. But otherwise, I mean, you see it happen all the time. You know, you walk to the restaurant and there's a sign that just says, we're no longer open for business. Yeah, and unfortunately, frequently, the employees find out at the same time the rest of us do.
Now, Ed, you mentioned the businesses that have 100 or more employees. What kind of notice do those kinds of businesses have to give to the employees prior to closing the doors?
If they're going to do a downsizing or close the doors, they have to give what's called a Warren Act notice. It's a federal law, and it gives, I believe it's 60 days notice, because they also give notice to the Department of Labor, because with 100 employees, you're going to get a huge hit on the Department of Labor also, unemployment claims. So it's a way to at least give some heads up.
Okay.
Now, I'll follow up here. Now, if let's just say the employer with 100 employees doesn't do that, what's the consequence?
Well, it's a federal action, and honestly, I don't know off the top of my head. We haven't had one in such a long time around here. I mean, it used to be SRS did it on a pretty regular basis, but we just haven't seen it.
Yeah, I imagine it got nipped a couple of times.
Yeah, that took care of that. Huh? Hey, we want to give you the phone number once again if you have any questions about going into business or perhaps some issues that come up. The number is 844-706-1212. We want to go back to what Vic had brought up at the beginning, which is trademarking your name. And you mentioned that nowadays, with everything being online, social media, it's more important now than ever. Why do you feel that way?
Well, because it used to be that if you were a small business, you were a mom and pop shop, the only way people found out about you was to drive down the street or see your ad on TV and the local media. But now, when you're on the internet, you're worldwide. And there are companies out there that do nothing but monitor for trademark infringements. And you'll know when you've infringed, because you'll get what's called a cease and desist letter from their attorneys. And so it's why it's really important to make sure that before you start using a name, we do some clearance and we do some research, and ideally we do a filing to make sure you're protected.
Now, if someone violates your trademark, what kind of consequence is there to that business that's violating your trademark?
So, Vic, what you're looking for is a likelihood of confusion. If someone's product or service might be confused with yours, then ideally what's happening is, or what may happen is, they're taking business away from you. And so part of your damages are proving the loss of business. Oh, that person called my competitor instead of me because they're infringing on my trademark. So that's the first thing that we look at is, well, what's the potential harm that taking that trademark or a confusing trademark has? And then if you register with federal trademark, you can also be additional compensatory damages. That's why it's important to do the federal mark. One, because it locks out everybody else from using it in the U.S. And any business has to be on the internet now, and so you're pretty much all over the country.
Ed, we're going to take a quick break, and then on the other side of the break, we'll take Walter's call. So Walter, if you can stick with us, we'll be back in just a few minutes. You're watching News 12 Law Call.
Welcome back to News 12 Law Call with award-winning broadcaster Neil Gordon. And from the Hawk Law Group, attorney Vic Hawk, with more than 30 years experience and millions of dollars awarded to his clients. Attorney Reed Sanders, born and raised in Thompson and known for his strong courtroom skills. With criminal law, former police officer, now lawyer Sean Merzlach. And with South Carolina injury law, trial attorney Chase Hawk. Plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
And welcome back. You know, no one likes to be insulted or described in harsh terms, right? But what if it was said that lacks written truth? You may be the victim of defamation. Sean Merzlach explains in tonight's legal brief.
Defamation cases are often very unique and complicated, but tonight we're going to keep it simple. Defamation is a false statement, a lie, written or spoken about you. Something so bad it damages your reputation, career, and your ability to make a living. Defamation comes in two forms, slander and libel. Slander is spoken while libel is written and published, including published online and social media. Intent can be a big part of defamation cases. Were the words spoken or written in a heated moment with little thought? Or was it a calculated attempt to get you fired, cost you a contract, or kill your credibility? Proving the latter can be tricky. But don't let that discourage you. When words do more than hurt, it's time to call a lawyer. That's your legal brief for tonight. I'm criminal defense attorney Sean Merzlach. Back to you.
And thank you, Sean. We're rejoined by Sean's colleague, Vic Hawk of the Hawk Law Group, and Ed Enoch from Enoch Tarver in West Augusta. And we're joined on the line by Walter. Hi, Walter. What type of business do you run?
How are you, sir? Simple construction business.
A construction business, okay. And do you have employees or contractors? And what is your question?
Well, I'm more or less a subcontractor. And I have maybe about 4 or 5 employees. And my problem is workman's comp.
All right. What's the problem, Walter?
Well, sir, I've got a workman's comp policy. They call it a ghost policy. And I pay the bill, and I 1099 my employees. And I talked to the Internal Revenue Service, and they said that's fine in construction. But I've been faced the last couple of years. I've had no problems. This year, I've got a $9,000 bill from workman's comp.
And you want to know why they're billing you and how that's justified?
Yes, sir.
Okay.
And Walter, that's your workers' comp carrier that's giving you that bill? Is that what I'm hearing?
Walter, did your workers' comp carrier send the bill to you?
Yes, sir, they did.
Right. And that's because they base that on payroll, and even though you're 1099ing these employees, they're treating them as your actual employee. When you give someone a 1099, what you're claiming is they're not actually your employee, that they're an independent contractor, but the insurance company is classifying them as your employee. I would suggest that you need to get to someone who does insurance law and have them take a look at it. But very well may be that you're going to end up owing that.
Yeah. There's a real danger, Walter, in just giving out 1099s.
Yeah.
The courts are going to look behind that. They're going to look to see if you control the activities of the employee. In other words, you tell them they have to be there at a certain time every day and they have to work 8 hours and they get 30 minutes break. You give them instructions on how to do things. The more control that you have over those individuals, the greater the likelihood that the court would find their employees. And then you're going to be stuck with a bad situation dealing with the Department of Labor because their taxes weren't taken out, or you could be dealing with a very difficult situation with your workers' comp. paying extra premiums that you didn't expect. And it's better just to bite the bullet up front and treat them as employees if they are really employees, if you exercise that kind of control over them. Independent contractors would be someone that you work with regularly and you tell them how much would it cost to for you to build this sidewalk, 100 feet of sidewalk. And then they decide when they're going to show up, what materials they're going to use, how they're going to build the sidewalk, et cetera, et cetera, et cetera. Those would be independent contractors that you could 1099. Is that fair, Ed?
Time, manner, and method. Those are really the three keys.
Right.
All right. Well, we want to hear from you. The phone number 844-706-1212. The lines are open. Before we go to break, Ed, people should know by now about Facebook and Instagram and all that. Do the employees get the message, do you find, about being careful what they post, or are you still hearing it from employers?
I'm not hearing it as much from employers in the last year or so. There was a big crackdown during Obama's administration on those social media policies and making sure that employees had the right to speak, because under the Labor Relations Act, the employees have a right to join together and complain about the conditions of their work. What they don't have a right to do is go on Facebook and talk about what a horrible person their boss is, or or libel or slander their employer. So I think that folks are starting to get the message on that.
Gotcha. Okay. Well, we'll take our next break. We still have one more segment. Again, the phone number for you to call, 844-706-1212, Small Business and the Law. Well, thanks so much for Vic for appearing for the Hawk Law Group this evening. They're headquartered in downtown Augusta. You can reach them at all fours with a 706 area code and hawklawgroup.com. Ed Enoch's website is enochtarver.com, and the phone number for you to call 706-738-4141. And we welcome Ed back into the program along with Vic Hawk, and our topic, small business and the law. You wanted to pick up where we left off.
Oh, absolutely. Now, I've had this experience come up recently. You mentioned that you can have a common law trademark.
Right.
And I had a good friend that had a business, and let's just say the business, he called himself A1 Fix It. And he's on the internet, and he's advertising in the various medias and things of that nature. And now all of a sudden, another person who is not providing the same or similar skill for that type of work is also advertising as A1 Fix It and taking business from him. Is there anything he can do about that? And does he have a common law trademark that he could work from?
Yeah, so he does, Vic. You earn a trademark by using that name in commerce. That's what's called a common law trademark. And what it does is it only allows you, though, to protect the scope of your work in the area that you do your work. So if his work is in the CSRA, then he can protect it in the CSRA. And the way we would do that is we'd file a lawsuit, and we'd immediately ask for an injunction, a court to come in and order that person to stop using that name and infringing on the mark, because the damage that they're doing is hard to undo. Yeah, I mean, when you're out there with a good service and a good mark, and somebody else starts trading on your name and running off customers, you can't take that back. Mm-hmm. So you got to stop them.
That's a loss of the goodwill
exactly
that you worked for so hard.
Right.
Yeah.
Good point. Again, for you to get involved, the phone number 844-706-1212. And Ed, the days of working for somebody for decades and decades, I think, has probably come to an end for the most part in the CSRA. A lot of people are starting their own businesses.
Right.
When they come to see you, how do you sort of get them set up? What are some foundational things that they should do?
Well, Neil, one of the first things we do is try to figure out whether or not they should be a corporation or an LLC, form some kind of protective entity that protects their personal assets from the business risks that they're going to take on. And and a lot of times people come to me and they think that they need one, but they may not. I mean, if they're delivering a service and they're the only one delivering the service, they're not going to be able to escape that liability anyway. I use that mischief guy on the insurance commercials. Like, if you're that guy, you're still going to be responsible for what you did.
Yeah.
But if that guy's your employee, you definitely need to have an LLC or a corporation to protect your assets. So
and
that's
good
the first thing.
And good insurance.
You mean the Allstate guy? Is
Yeah.
that what you're talking
I'm
about?
about the mischief guy.
Yeah.
And then the next thing is, well, what name are you going to use? Have you made sure that you're not infringing on somebody else's trademark? That's a Google search, which is a trade name. But it goes beyond that. If we're going to do a search, we actually have a service that searches every Secretary of State's office in all 50 states, and then also publications, so that you get a very comprehensive view of whether somebody else is using that name.
Excellent. We do have a call. We've got John from the Augusta area. Hi, John.
How are you doing today?
Great, fantastic. Are you in business for yourself?
Actually, no. I was an employee.
Okay. Sure. How can we help?
I've been a long-term employee of a business, and they have treated employees completely differently and have made them follow different rules. And if they terminate you and you can prove that they have treated employees differently, is there anything that employee can do about it?
Well, John, are you saying that you were treated differently?
Most definitely.
Okay. Well, in Georgia and South Carolina, the biggest protections you have as an employee are the federal discrimination protections, non-discrimination laws, age, race, sex, national origin, veteran status. There's a list, but you, but if you've been treated differently on one of those bases, then you certainly have a claim, and you have to move quickly on it because you only have 180 days to file that with the EEOC from the time that whatever the discrimination was happened. And so you want to get to someone pretty quickly.
Yeah. And John, to make it clear what we're talking about, if they treated you differently because you're male, treated you differently because you were of a particular race or national origin or a particular age group, there are federal protections that you are granted as a result of past discrimination that's been identified. The employer has wide discretion to treat employees differently for legitimate reasons, or just say, for example, there's a preference for, he just likes this person's work versus someone else's. So let's try to get George.
Yeah, we've got Tim from Augusta. Hi, Tim.
Hello. How are you?
Great. What is your question for Ed?
Well, my question is reference to patent.
Okay.
And, I was patent in 2012, which is a security system. And I was watching the late news one night, and there's a company out in California that has a very similar product that I have patented. And I've been trying to contact law firms here in Augusta about patent infringement, but I'm getting a dead end.
All right. We're almost at the end of the show.
30 seconds.
All right. Well, I'll tell you really quickly, you're going to find a dead end because there's no patent lawyer that I know of that practices in Augusta. There's just not enough of that work in Augusta. You have to go to Atlanta. There's actually some in Greenville because that's a federal practice, but we don't have any attorneys practicing here.
And there's a few in Columbia as well.
Sure. Vic, Ed, thank you so much.
Thank you.
Have a great work week ahead. We'll see you next Sunday.
Thank you all for calling.